Well, hello and welcome to another edition of Talk Time. Now, this week we're going to be talking about governance. What is the genesis of governance? How did some people become our governors? How did some people become the rulers and some the ruled and so on? What is the role of the Constitution in all this process of choosing leaders, of dispensing with leaders? And when there are disputes, how are we supposed to be resolving these disputes? The principle of separation of powers, what does it really mean? What is the role of the judiciary? Is the judiciary the guardian of the democratic experiment, or is this just another institution in the whole process of ensuring civility in the choice of leaders and so on? This morning, we are exceedingly privileged to have with us somebody who understands these issues. Welcome to Talk Time. And welcome to Talk Time. And as I indicated, we're going to be talking about governance, its genesis, how things fit together, the role of the judiciary. Is that different from the role of the executive? How different is that from the role of the legislature? What are the ingredients of a democratic order and so on? These are some of the questions we're going to be posing today. And with us in the studio is a former Justice of the Court of Appeal, Justice Issac Douse, and he'll be dealing with us this morning in all of these areas. Sir, you're welcome to the studio.
Thank you very much.
Yeah. Now, what is the genesis of the current democratic dispensation? What is the genesis? Where did it come from?
Let's be brutally frank. Government started originally by a group of marauding armed men who will collect protection in forms of cattle and corn from farmers in order to protect them against other groups of marauding armed robbers. With time, they graduated to become monarchs and led armies, conquered other people, looted and plundered their properties to fill their bands. A typical example can be even from the Bible, when Saul was asked by God to go and decimate the Amalekites and kill all their property and take nothing away. Kill everybody and kill every property. That is a typical example of how monarchs behaved. They will loot, they will rob and pillage. Now, with time, life became so brutish and short and nasty. Philosophers started thinking about how best to change government without so much bloodshed and violence. So Plato and others started thinking about better ways of doing governance. In fact, in England, they signed the Magna Carta in 1312, which restricted the power of the king to make war and collect taxes within England itself. So with time, monarchs were losing their position. And a typical example of a government system which started with vote is America, United States of America. And even then, they had their fair share of civil war, the war to unite the United States, and then the civil war, which occurred after Abraham Lincoln took power through a vote. So wise men have decided that it is better now to use less violence in the selection of leadership in the country. And that led to the formation of political parties which are supposed to be ideologically based, so that like minds will join parties with like political ideology and arrange to get power to manage the affairs of state in accordance with their political ideological perceptions. However, from time to time, things get out of hand and people resort to their old methods of the using of guns and ammunition and violence. So, typical example is occurring right now in the United States. Trump will not accept his defeat and is organizing mobs to riot and so on and so forth. So the old instinct in man to apply violence when reason will not work is still hiding somewhere in the corner, and from time to time it will surface and haunt us and terrify us.
But it has surfaced in Ghana. I mean, the last elections, December 7th, 8 people were left dead.
It's as unfortunate as it is unpredictable. And I think every well-meaning Ghanaian should condemn it roundly. And as much as possible, the perpetrators should be brought to book. If investigations show that those deaths were undeserved. Otherwise, everybody should condemn it, and those who have perpetrated it should be punished like the one, is it Kola? Is being, at least he's facing the law right now, and his likes in the other parts of the country should also be exposed and to face the law. Once that is done, the opacity and the darkness in which these kinds of things are done will become a prohibitive factor for people who will want to engage in those kinds of political misconduct.
What does the Constitution say about armed groups, operating within the political sphere? We've heard about the vigilantes and so on. What is the constitutional position on the raising of armed groups?
The Constitution, I can't mention the article now,
it's not necessary.
but generally frowns against the raising of private armies. And that is the reason why the private security companies cannot bear arms. Because once they begin to bear arms and they are trained in handling of arms, they become private armies. And the state has well-defined organizations which are entitled to bear arms, particularly the armed forces and their various divisions and the police. Other organizations which are paramilitary, like the prison service and the immigration service, have a limited capacity to bear arms. So you will find that there is no concentration of prison officers or immigration officers or customs officers who can behave like an armed force. They can raise arms to quell a particular small issue. But if it goes beyond them, then they have to call in the police or to call in the armed forces, depending on whether the threat is external or internal. So that, technically speaking, if a person commits an offense and is arrested by an immigration officer, as soon as practically possible, that person should be given or surrendered to the police, who have the equipment and the authority to investigate further and institute prosecution and so on and so forth. Similar thing applies to customs, similar thing applies to immigration and so on and so forth. So anybody who creates anything outside the organizations that are created by law as the security forces commits an offense.
So how come that we have all of these groups, so many of them, armed, you know, and they've been causing mayhem for a considerable length of time, when indeed all of us know that their activities are unlawful?
It's unfortunate, but let's be frank about it. Earlier on, during the revolution, there was this CDO, Civil Defense Organization, created under the PNDC, which were acting outside the police force or the constitutionally established security forces. And I think that despite the dissolution of that organization on the advent of constitutional rule, certain political parties still deem it necessary to have people on the dark side who have been given arms for their private personal defense. It is dangerous, it might be discouraged, but I think also that in the process of doing that, the architecture of the police service needs to be revised, because certain elements of the police force have lent themselves to be abused by the political operatives who come and go. And therefore, politicians generally seem not to have confidence in the police when they come into the minority. And they think that they should have certain forces to support them. Once every other while, these same elements turn against their masters. And therefore the masters must know that the processes they have adopted ostensibly for their own protection can be dangerous for they themselves. And I don't need to give any specific instances, so everybody knows. So but once the police service begin to be more professional, these kinds of situations will no longer be there.
Can we safely say that the judiciary has played its role, its expected role, in curbing the raising of private armies and so on?
Because the judiciary itself was a victim.
I know. But to what extent has the judiciary contributed to the fight against vigilantism?
See, the judiciary can only fight against vigilantism if the executive takes the first step. The judiciary cannot investigate any offense. It is the executive arm which will do the investigation, and when they deem it necessary to prosecute anybody for any perceived offense, that is where the judiciary will be called in. And I can assure you that no judge worth his salt would allow and give free vent to miscreants acting under the guise of vigilantes or private security people to take the country to a ransom.
But we have incidences in which judges have been threatened with fiscal harm and so on, and those who did that appear to be getting away.
They will get away because the force which supports the judiciary It's the very force which I refuse to bring those people to book. A judge is armless. He only has a pen and his mouth. Whatever decision he takes, if the police will not enforce it, he is crippled. He can't do anything.
Haven't there been instances where judges have refused to act?
I'm not too clear in my mind of the instances where judges have refused to
There is, for example, the Kennedy Japan case, where he actually makes statements which are deemed to be in contempt of court, and so on. He's arraigned before a court, and God knows what has happened. Nothing has happened. As a result of some judicial maneuvers.
That matter is still sub judice because it has not been concluded. No judgment has been given, so we cannot rush to conclude that the judges are complicit and will allow abuse of themselves. The law of contempt has always been a very controversial law. Some people think that because of the way it operates and is applied, it is capricious and vicious and very personal to the judges who are doing it, and therefore people are reluctant to pursue that line of action. But as far as I'm concerned, as long as the matter is still not conclusive, we cannot come to a conclusion that Kennedy Japan is out of the woods.
Isn't it possible to compare how one case is dealt with as opposed to another? Is that not possible? For lay people like me, can you not come to a conclusion that one case is dealt with expeditiously, and then in another case there appears to be some reluctance, to make progress?
Judges go to the table, let me use the dining table, and they eat what they are served. And those who serve them will determine what kind of decision the judge will take. So often rubbish in, rubbish out. So if the people who want the judge to take action put the right materials before the judge will obviously take the right decision. So where a matter is referred to the court, and those who are to supply the tools with which the court will work are reluctant to supply the goods, there's nothing the judge can do.
In the case of contempt, for example,
Yeah.
What is the role of the judge? My understanding is that the judge determines what is contempt, and the judge can actually order that a person or persons be brought before it for contempt. This is unlike other criminal offenses.
There are contempt is generally an act which constitutes an affront to the dignity of the court. There is contempt in the face of the court and contempt outside the court. What happens most of the time is that when the contempt is made or the act of contempt is committed in the court, it is punished instantaneously. You may not go home to think about it before you end up in jail. But where it is committed outside the court, it may need the intervention or the interaction of an investigative organization.
The state actor.
Yes. And then when I talk about that, then we are talking about the police and the Attorney General's department. If they are not willing to act, nothing will happen. That is where the issue of nolle prosequi becomes dangerous. Because if you don't have a very firm Attorney General, they can always enter nolle prosequi and free miscreants. So we need not only a firm police organization, but also a very firm Attorney General. When I talk about Attorney General, I'm talking about the state attorneys who operate with them. Because every senior state attorney has a certain amount of authority to enter a nolle prosequi.
Well, we were talking with Justice Issac Douse. I hope I got the name right.
Douse.
Yeah. Who is a former Court of Appeal judge. And we're talking about governance as it relates to the law, and especially the judiciary and the Constitution. We're going to take a short break here. And when we come back, I'd like us to take a few steps backwards to a statement he made about the role of the police in ensuring that civil administration succeeds. He mentions difficulties with the police structure, and so on. We're going to go into that. So, short break. Hello and welcome back to Talk Time, and we are in conversation with Justice Issac Douse, who is a former Court of Appeal judge. Now, sir, we spoke about the role of the police in fighting, preventing vigilantism. What do you think are the difficulties that the police faces in this attempt to bring some civility to the governance system?
The first difficulty that the police face is the process of selection of the chief executive of the police. In my humble opinion, the processes make whoever gets elected as the chief executive of police need to show gratitude to the appointing authority. And once the chief executive of police feels the need to show gratitude to a president, the firmness with which he will operate is lost. And the structure of the police under the Constitution is such that this kind of situation is bound to happen as often as possible, because the president can always dismiss the chief executive if he feels displeased with one step or the other that he will take. So you will find that the hierarchy of the police are all looking over their shoulders and keeping a third and fourth ear to find out what repercussions or what rumors or what winks and frowns the executive has over whatever action they take. And that is very unsatisfactory.
Can we change this situation? Is it possible to change the arrangement under which the executive appears to have overwhelming power over the police?
It is capable of being changed. It can be changed if a police college can be formed. A police electoral college can be formed, and senior police officers who go into conclave and determine which of them leads them for the president to appoint.
So the president will still be the appointing authority?
Yes, but in this case, you only be doing a ministerial job. The conclave will appoint their own chief executive, present it to the president, who will perform a ceremonial appointment. And the president cannot, repeat, not remove such a person. It's only the conclave again which can meet and cause his removal.
That would be a significant amendment to the Constitution.
Certainly, yes. Certainly.
Do you have any idea how the current system operates? Because I'm told that it involves the Council of State, it involves other institutions and so on.
Yes, the Attorney General is part of the, or his representative is part of the Police Council. The Vice President is the chairman of the Police Council. The representative of the Ghana Armed Forces is part of the Police Council. I think there's no judiciary and the Police Council. But if you look at all these persons who formed it, a member of the, I think a member of the Council of State, all these persons are necessarily appointees of a president. And in our environment, you do the wishes of your appointer or you quit. Mm-hmm. So unless the long fingers of the president are cut short in certain respects, a president's finger will be in every cake and every pie. And therefore there will be no freedom. And where there's no freedom, a policeman cannot act professionally.
What about the maintenance of professional standards internally? I mean, if you take out the political influence in appointing the chief executive and so on, being on the judiciary, having been on the judiciary and a very senior lawyer at that, are there any other problems with the enforcement of professional standards in the police service?
Yes and no. Yes, the rules governing the professional ethics in the police service are excellent. But it appears something called protocol in the enlistment of police officers dilutes the quality of persons who go into the police service. And those persons who go on the protocol most often turn out to be the bad legs in the police service. And more often than not, it is they who become escorts to political appointees. I think it's dangerous. If political appointees need police escorts, like they do to us on the bench, the police command in the environment should select who should go on guard duties or as escort duties in the judiciary and for the ministers and so on and so forth. I think it's dangerous for the ministers themselves to handpick persons to be their escorts. And that's the reason why a police officer will vote and show his vote. If any other ordinary person does not understand the secrecy of a vote, I will not complain. But for a police officer in uniform to vote and exhibit the vote and therefore render his vote open to the public and no longer a secret, there is something that we need to do about that.
What are the essential principles that the Constitution establishes with regards to elections in Ghana? Are there some principles that the Constitution establishes?
First and foremost, and most important, is the secrecy of the vote. It gives you the freedom from fear that someone will say, you did not vote for me, and therefore there can be repercussions. That is the reason why the secrecy of the vote is sacrosanct. In any environment in which the vote becomes exposed, there is no vote. That is my personal opinion. A vote is only a vote when only the ballot box and the individual know what has been done. Secondly, the vote must be cast in a free atmosphere. When I say free atmosphere, I mean there should be nothing close to intimidation. In fact, as much as possible, if police should be there, they should even be in mufti. They shouldn't be in uniform. That is when you can say that it is free and fair. I know miscreants will come and misbehave, and if a policeman is standing there, it might deter him. But the policeman can be effective even if he's not in uniform. In fact, at the police station, if things go well, there should be no arms at all at the police station. I know people who misbehave, but civilians can act in their own self-defense when one or two individuals come to misbehave. The third one, apart from the free atmosphere, there must also be fairness in the process of adding up and declaring the vote. When I say fairness, I mean transparency. As many people as possible should be present to see what is going on. And I dare say that the counting should be done in the open and where possible in broad daylight or clear artificial light, so that everybody will know what has gone on. Those things lacking, the process of voting will appear to be flawed and may be unacceptable. And when the feeling of unacceptability comes in, then the tendency to adopt other uncivilized means of having an issue settled are likely to be applied.
What are the qualifications for candidates in the election? Who, for example, does the Constitution say can contest to become President of Ghana, and who does the Constitution say can become a Member of Parliament?
To be honest with you, some of the conditions for becoming President or Member of Parliament are not good enough. If all you need to do is be 21 years of age and not certified as crazy, and therefore you can stand and win an election, I don't think it's sufficient. I think a certain kind of track record should follow you into standing an election. Good track record should follow you. Even if you are young, then you must have a track record from school, which shows that you are competent and capably gifted young person. For example, someone who has never held an official position in school, for me, is not qualified to be a young Member of Parliament. Because in school, you are trained in management and so on and so forth. You can be a very good house prefect, a very good school prefect, and so on and so forth. That is a record of exposure to management, which can make you qualified to be a member of parliament. And to be president, there is a certain amount of exposure that you must have. Not just be 40 years and above, because not everybody who clocks 40 years, who has clocked a clean and a clean and genuine track record to become a president. For me, a person like that should at least distinguish himself in the profession which he has chosen, either as a lawyer or as a doctor or as a soldier or as a journalist or whatever it is. By 40 years, you should be a leader or very close to the leadership of your profession. And if you are transiting from there into public life as president, I think all of us will have the comfort to know that we'll be very well taken care of by our president.
One of the issues which has come up, and you are a judge or a former judge, so you should know how to manage this, is the issue of dual citizenship. Is it a necessary qualification for contesting elections in Ghana? Because I've heard other lawyers say that it is not a necessary qualification.
Unless a disqualification.
Disqualification, yeah.
You see, you know, and I know, that most Ghanaians who get the dual citizenship get it as a matter of convenience, so that they can get privileges in the host countries. And that is why most Ghanaians get a dual citizenship. Others also get it because of marriage. And seriously speaking, it is only a fear that the person who has atoned loyalty to another country cannot become a very important member of our executive or of our legislature, so that our national secrets will not be taken out. You see, which secret is there in Ghana that France doesn't know, or the US doesn't know, or for that matter, Germany doesn't know? They know more of our secrets than you and I know. So if that is the only reason why holding a dual citizenship should be an impediment, I think it is not. It's a non-starter.
But what does the law say about dual citizenship and political office?
The law says that if you hold a dual citizenship, you need to renounce the act one before you can become a political license holder. It is based on the fact that if you hold a dual citizenship, so the preposition that if you hold a dual citizenship, you can easily divulge state secrets to your other states. But you see, you know that these things don't work. Even sitting presidents can betray us, whether they have a dual citizenship or not. We know people who go and take bribes, small bribes, and sell their whole country in Africa, sell their whole country for a mess of pottage. So even though it is necessary to protect our sovereignty, I don't think that these prohibitions about dual citizenship solves the problem. You remember Fujimori? He was born and bred. He didn't go to apply for citizenship anywhere. He didn't really have to renounce his Japanese citizenship. You see what he did. So what's the big deal about being a dual citizenship? All the people, mark them, all the people who have children who are in the US, they have acquired this in the dual citizenship there. Mm-hmm. It doesn't make them less Ghanaian. I remember one day I was at the airport and a Ghanaian came and he had a US citizenship and he was being asked to go and join the foreigners lane. He started speaking Twi. Now my baba Mikroma, most of joining foreigners and me all one come with Asante. So you see, these are some of the things. Mm-hmm. There are theories which are fanciful, but which don't go any far as I am concerned. Yeah, you were going to ask a question.
Yeah, one of the issues that is coming up strongly has to do with the hierarchy of the courts, and also what parity must necessarily exist with similar courts and so on. I mean, I'm talking about a case in which you have two high court judges deciding a similar case, and each of them decides differently. How come? Is it normal? And how can there be a remedy?
It is highly possible for that kind of situation to arise. As I said earlier on, what is presented before the judge determines what decision he takes. So if the case is not properly presented before the judge, he might take a different decision. The cases on the outside, in the shell, may look similar, but deeper in, there can be other factors which should make the two judges face with similar, in inverted commas, to take different decisions at the same level.
Shouldn't all high court judges be guided by the same principles?
All high court judges are guided by the same principle. There's no doubt about that. You have principles arising from constitutionalism, arising from procedural issues, arising from substantive law, and so on and so forth. But what will form the basis of a decision will be highly premised on the quality of the materials presented before the judge, which he has to dissect, digest, and announce.
Can you give a real practical example? I mean,
Yes.
two high court judges, and the high court is one court.
Yes.
Okay, but two high court judges.
Yes.
One decides that at all material times, constituents must have representation in Parliament. And one decides that it is not necessary at all material times for constituents to have representation in Parliament if that representation is faulty. These are two ends, two different ends.
To avoid the occurrence of this, the judiciary has published from time to time special manual on how to proceed on election disputes. The fourth manual has just come out. And if this kind of thing occurs, one of the judges must be patently wrong. There's no doubt about that. One of them must be patently wrong. And in an environment in which it may not be possible to take advantage of an appeal, because the timeline is too narrow. That brings me to another issue. I sincerely believe that we have copied the American system wrongly. We have only 30 days within which to transist. I think it is highly ambitious and unnecessary. Winning an election is not a coup d'etat. And one should be willing to wait at least 90 days for teething problems to be resolved before we proceed to transition into a new governance process. So you see, America votes in October, and transition is in January. Sufficient time. If you look at the new election dispute manual that has been issued, timelines have been drawn to make sure that within 40 days of the announcement of the results of an election, disputes can be resolved before the courts. But the 40 days is after things have gone out of hand. If the two parties, now that by providence the balance of power in parliament is on an even scale, is an opportunity to amend that part of the constitution which gives us such a short leash. Because if a president is not sworn, removing him legally by judicial means is no problem. But once he is sworn and he has become the commander-in-chief of the armed forces and the police and all the instruments of coercion in the environment, it is difficult to imagine a situation in which a sitting president who has all these commands will easily
surrender power.
Because as I said earlier, the judiciary has no power if the executive doesn't empower it. So it is possible for the Supreme Court to pronounce, and the president who has already been sworn in and has gone through the process of electing his ministers will say, okay, hi gentlemen, the Supreme Court says you should pack and go, so come on. Oh yeah, make you go.
Yeah.
I don't know whether it's even happened in America. It will be very difficult even in more sophisticated environment than ours.
While viewers were talking to Justice Issac Douse, who is a former Court of Appeal judge, and we're talking generally about governance, the relevance of the Constitution. We are looking at our electoral laws. We are looking at the use of violence in elections and other related issues. We're going to take a short break, and when we come back, I have a couple of interesting questions. Which of the courts has jurisdiction to hear cases with regards to elections, and what cases may the different courts hear? So when we come back, we're going to be delving into these matters. Short break. Hello, welcome back to Talk Time. And today we are talking elections, we are talking constitution, we are talking about violence, and we are talking about so many things. And we have the very special privilege of talking with Justice Issac Douse. Sir, does the Court of Appeal still have the authority to take appeals from the High Court on election cases?
Yes, it does.
Regular appeal process?
Regular appeal process, yes.
But we've seen a case where one case actually moved from the High Court to the Supreme Court. I'm talking about the Lilobi, Akpabi, Akpafu,
Santo Kofi, and so forth.
Under what circumstances did it move from the High Court to the Supreme Court?
I think under the new regulations, because of the speed that is needed to resolve the problem. That is why it has to move from the High Court to the Supreme Court directly, so that time being of the essence, this sense will not.
Okay. The Supreme Court hears petitions with regards to the presidential elections.
Yes.
How is the paneling done? For example, is it possible for all the Supreme Court judges to sit on the case? Who decides who sits on the case?
The Chief Justice has the power to select. When the full membership of the Supreme Court was 9, it was possible for all the 9 to sit as a full bench. And it was possible to have a bench of 5, a bench of 7, and a bench of 9. And the number of seats, physical facility, is 9. So now we have more Supreme Court judges, but it's not possible with respect to the physical space available to have all the 15 or 17 members to sit. In fact, there is a principle also out there which gives the Supreme Court an opportunity to review a decision if something should go wrong. Therefore, it is not desirable, it's not proper or fair for all the members to sit at once, because then there will be no fallback position. So, 2 reasons why all the Supreme Court judges cannot sit at once.
Now, if there's suspicion of bias against any member of the bench,
Yes.
how is that dealt with?
Well, whoever, empaneling the Supreme Court is not like empaneling a jury, where you can raise objection without giving reason.
Oh, in the case of jury, you can raise objection without giving reason.
Yes.
Oh, okay. I didn't know that. Okay.
I think you can raise objection against 2 or 3 without giving reason. If you go beyond that, then you must give a reason for why that one. But in the Supreme Court, taking a position that the Supreme Court judge is likely to be biased against you, it cannot be done lightly. It's a very serious allegation. And when you say a person is biased, you are saying that the likelihood of bias means the person is going to be unfair to you. He will not do justice to you. He will not follow his oath to be fair and candid. You need to give reasons why.
Just reasons or evidence?
Reasons and evidence.
Okay.
In fact, the reasons will be based, the evidence will be based on the reasons. So it is not a very easy thing or a very enterprise to engage in. You understand?
I fully understand.
Yes.
But who determines, who makes the final determination? I mean, there's a panel of 3.
Yes.
There's a panel of 7.
Yes.
And I raise objections based on bias against 1.
Yes.
Who determines whether or not my case is valid or not?
One would have thought that the person against whom the allegation is made will recuse himself. Another person will be added to make the 3 and take the decision. Because if the person against whom the objection is raised ceases to take the decision himself, then he will put himself in a very compromising situation. So normal practice will be for the person against whom the allegation of bias is being taken not to participate in it, because we say "Nemo Judas in causa sua." You cannot be a judge in your own case. So if you are the accused, it is nice for you to stand off, and then your colleagues will take the decision. But for most of us on the bench, if anybody thinks that you will not be fair to him and he raises it, we say, well, this is not the only case I'm going to sit on in the world. Why not? Let me go and take a rest. Put somebody else in my place.
In the United States, for example, I mean, if a black person was being tried and the jury was all white, it serves as a sound basis for raising objection to the jury.
Yes.
What about Ghana? Can you raise objection to a jury on the basis of the ethnic composition of the bench or the jury?
It is possible. It is possible. If it depends. Say an Akan man has been murdered and a Dagoba man has been charged, and the panel is all Akan. Obviously, there could be fear that the Akans will give judgments against the Dagoba man who has been accused of the murder. But look at the reverse of it. Assuming that the murdered is a Dagomba man, and the accused is an Akan man. Assuming that the murdered person is a Dagomba man, and the panel is all Dagomba, the Akan person who has been killed has no mouth. I cannot object, and nobody can object.
But can't you assume that he's being represented by the prosecution?
The prosecution normally doesn't raise a lot of objection. The prosecution doesn't normally, the selection.
So ethnicity can become a basis for raising objections.
It is a fear, and anything you fear gives you a cause to raise objection. The person may be as fair in their own minds as they possibly can, but it is the fear of the accused which is operating. The person who is being tried which is operating, not the fairness of the people who are there. Sometimes it happens that probably even the fairest person is objected to and taken off. I haven't heard throughout my practice objection being raised because of ethnicity in Ghana. I haven't heard.
What are objections on party affiliation, on the basis of party affiliation?
If it's a political case, yes. But if it's a business case, I don't think that you can import party affiliation into a business case. That would be untenable.
Well, viewers, we are talking with Justice Douse, who is a former judge of the Court of Appeal, and we're talking about many things: election petition, constitution, the police force, and so on. We're going to take a short break now, and when we come back, we'll take a final look at the processes that are unfolding before us in the courts. What should we expect? How may we be guided? You know that in the past, a lot of people suffered from unsavory comments about the courts. I mean, people went to jail for contempt and so on. For those of us who will be watching these proceedings, what should guide us? And then the other question would be that there's a lot of clamor for live coverage of the proceedings in the Supreme Court. Does live coverage enhance the law, the interpretation of the law, and so on? So these are the issues that we've been dealing with in the last segment of this interview. A short break. Well, welcome back to Talk Time, and we are talking with Justice Douse, former judge of the Court of Appeal. Now, first, sir, live coverage of the proceedings in the Supreme Court. What's your view?
You see, if you are talking about transparency, and this matter concerns every voter who voted in the last elections, I think, as was done in 2013, it should be possible to have the same thing done this year. What is good for the goose must be good for the gander.
But could there be a basis, any basis at all, for rejecting live coverage?
It will be unfortunate. And once again, it is a collaboration between the state and the judiciary. The state must be prepared to put the live coverage, and the judges must also agree that if something must be seen to be transparently done, then doing it in the open will ensure that everybody understands where he stands in relation to the final decision that will be taken.
Would live coverage not be injurious in any way, to the bench or to the applicants or the respondents? Would it not be injurious in any way? Is there no way in which live coverage can be said to be injurious?
I'm yet to see one. I've held a commission of inquiry before with live coverage, and it was tough. But it draws out the best in you. If you are doing it in the open and you want to be transparent, when everybody is watching you, it's difficult to misbehave when
Now, what about those of us who will be sitting at home and watching television and reading the newspapers and listening to the news? How may we avoid trouble?
Don't make any prejudicial statements. Don't conclude for the court. Don't, for example, say, as some people have said, that because some judges were appointed by a certain government, then they must favor the government. Or that because some judges were not appointed by a certain government, they must act against the government. You see, I have had the privilege of working with many of the people who are on the Supreme Court bench now. They are people of quality. And if they do a professional job, I don't think there's a need to fear. I've worked with a lot of them. I know a lot of them personally. And they are people of quality. If they will do a professional job, nobody should fear. And I believe they do a professional job.
Can I ask a dangerous question?
If it's dangerous, if I see the danger, I will not answer it.
Will they do a professional job?
Knowing them, from where they rose from to where they have reached, I think they should be able to do a professional job. Because anybody particularly who has risen through the ranks to become a Supreme Court judge, didn't take one step to get there. They have been dyed in the wool, tried and tested over a long period before they ended up in the Supreme Court. And for that reason, I can assure you that they will do a professional job.
Now, sir, here I am. I'm not an applicant.
Yes.
I am not a respondent in the case.
Yes.
Sitting at home, if at the end of the day, after the decision of the court, I find reason to believe that the court did not act professionally, bearing in mind that I'm a Ghanaian citizen who is affected by the decisions of the court, what remedies are available to me? Are there any remedies at all?
The remedy you have is comment.
Just comment.
You can't, because you're not a party, strictly speaking, you can't appeal against the decision. But at that stage, the comment can be as vicious as you possibly can, because the case has been dealt with. It's no longer sub judice. It is not prejudicial to the outcome of the case. Whatever way you see it, you can go as deep or as high as you like.
But it will not change the decision.
No, it will not change the decision.
So
But-
it's just event.
Event, that is why we have freedom of speech. At least, if you can't change it, you can talk about it. And it is satisfactory to talk about it and satisfy yourself that you have said something about it.
Your brain will top.
Now, where you have been given a heavy knock on the head and you are not allowed to cry, that is where the problem is. So after the case has been dealt with, you can do anything, make any comments about the facts and the way they have been handled and so on and so forth. But it may not be fair to attack individuals and their individual capacity. You can attack the decisions they have taken, but you cannot launch individual attacks on the personality.
Veering towards libel.
Not exactly. Yeah, you may veer towards libel. Yes.
Yeah.
You may veer towards libel. Yes. Because if you are going to launch a personal attack on them, then you must also have sufficient material upon which to launch the personal attack.
Well, thank you very, very much for coming to the studio, and we are actually hoping that in the course of proceedings we can benefit from your experience and knowledge, But thanks so much, so very much for coming to the studio. Thank you very much, sir. Well, viewers, we've been talking to Justice Issac Douse, who is a former Court of Appeal judge, and we've been talking about many things. Please do not flip your dial yet, because Pan Africa has a lot to offer. We're just about to bring you our entertainment program, Swift. The news will follow this one, and there are lots and lots of entertainment, documentaries, all of that on Pan African television. This is the biggest television platform in the country, so please stay with us until we meet again next week. It's bye-bye from all of us at Pan African Television.